Court officer, please put the proceedings on the record.
Cette session spéciale de la Cour pénale internationale marque l'ouverture officielle de l'année judiciaire. The special session, marking the formal opening of the Judicial Year, is now open.
Madam Secretary General of the Commonwealth, President of the Assembly of States Parties to the Rome Statute, fellow judges from around the world and of this court, Madam Prosecutor, Mr. Registrar, Mr. President of the International Criminal Court Bar Association, Excellencies, ladies and gentlemen, on behalf of my colleagues and all the staff and functionaries of the ICC, I welcome you to the special session of the International Criminal Court for the opening of the Judicial Year 2020. Last year ended for us on a positive note in the affairs of the ICC, with a salutary buzz about review of the Rome Statute system for better delivery of mandate, a review that was formally blessed by the Assembly of States Parties last month after the idea had been strongly embraced by the leadership of the court as well as other stakeholders. The review is long overdue, not only for the court itself, but also for the Assembly of States Parties that was established to fund and support the court. There is a lot that can be improved in the delivery of international criminal justice under the Rome Statute system, and it is up to the court and the Assembly of States Parties to do just that. But ladies and gentlemen, we should be clear that what we embark upon is to improve something that is already extremely valuable for our common humanity. Our openness to exploring all the ways in which delivery of mandate can be improved should never obscure the fact that the ICC is already a phenomenal achievement in the multilateral international order. I say this against the background of brazen attacks that the court has recently endured simply for seeking to act on its mandate as defined in the Rome Statute. It needs, of course, to be stressed that these attacks form part of a pattern of open disdain that are seen in some quarters in recent times against the multilateral international order of which the ICC is a major part. In the circumstances, one can see a real danger that the supporters of the ICC may succumb unwittingly to wearing anxiety about the court, allowing them to see little else but negativity all around. But I urge calm. The sky is not caving in on the ICC, and it will not. There is much reason for positivity in spite of the imperfections that are in the very nature of the project. With 123 states parties from all corners of the globe, the ICC edifies the organized world stands against impunity for genocide, crimes against humanity, war crimes, and the crime of aggression. The court's trials have spotlighted sexual violence during war, abuse of children as soldiers, persecution of population on grounds of their otherness, and countless other heinous crimes that come in the form of intentional attacks on civilian populations. With the associated mandate of the Trust Fund for Victims, ICC's work has afforded tangible reparation to victims. Above all, the ICC has sent a clear message that misanthropes who abuse power while subjecting innocent victims to extreme agony will be haunted by questions of accountability, eventually to be answered before an international court of law, when national courts prove unable or unwilling to ask those questions genuinely. Indeed, the ICC's work exerts necessary pressure against rampant, malignant power. That explains much of the strident hostility that it has endured, as well as the paradox that some leaders may be reluctant to vacate political office in the hope that a notion of inviolable immunity would defer or obstruct accountability before the court. But last year, the court's appellate chamber clarified that no such immunity exists even for heads of state when their cases fall within the court's jurisdiction. It all speaks to the ICC's clear deterrent effect. Deterrence results from the risk of robust prosecution before an independent court of law. One clear example has been the court's effect in helping to reduce election violence in several African countries. 4 days from now, ladies and gentlemen, on the 27th of January precisely, the world would observe the Holocaust Remembrance Day. This year would mark the 75th anniversary of the liberation of Auschwitz. As we mark that event, we must always remain mindful that the world, the post-World War II international order, has always regretted that before that war, there was no institution like the ICC which might have acted as an obstacle to the temerity or free will of the architects of the Holocaust. We now have the ICC to give applied essence to the global commitment of never again. We must continue to support and sustain it so that we can have precisely that obstacle to the temerity and free will of those who commit the genocides, the crimes against humanity, the war crimes, and the crimes of aggression of tomorrow. U.S. founding father Alexander Hamilton once described the judiciary as the weakest branch of government. It is no sign of weakness to accept that axiom. This is particularly true in the notoriously imperfect realm of international law, which unavoidably depends on the states themselves for its implementation, even for basic functions. The ICC is at the mercy of states for the execution of even its most critical and basic functions, including the arrest and surrender of suspects. The ICC also anchors the indispensability of international law in a world that values peace and human security. So, U.S. Supreme Court Justice Robert H. Jackson put it at the dawn of the modern international order in 1945 when he observed, quote, "Those who best know the deficiencies of international law are those who also know the diversity and permanence of its accomplishments and its indispensability to a world that plans to live in peace." Yes, the ICC personifies the imperfections of international law, but it remains a mechanism of great value to humanity, not least because it has truly served to loosen the grip of tyranny on humanity in our time. With those few words, I welcome you once again to the ICC to mark the formal opening of our Judicial Year 2020. Before giving the floor to the prosecutor of the court, we will hear the first of three musical intermezzos performed by the Lazarus String Quartet, which consists of four talented young musicians. Thank you very much. Now I invite the prosecutor of the court to share some reflections with us. Madam Prosecutor.
Madam Secretary General of the Commonwealth, Mr. President of the Assembly of States Parties, Mr. President of the ICC, honorable judges, Mr. President of the ICCBA, Mr. Registrar, learned colleagues, Your Excellencies, ladies and gentlemen. I am grateful for this opportunity to share a few reflections on the occasion of the opening of the ICC's Judicial Year. I subscribe to the sentiments just expressed by the President regarding the current climate of the multilateral international order and the challenges that the court faces. We are 3 weeks into 2020, and already we are witness to a number of crises in the world that underscore the international imperative to find immediate and long-term solutions to the peace and security dilemmas, and indeed, the direct assaults of international law that threaten the well-being of citizens, young and old, near and far. The ICC, as the only permanent international criminal court, is a crucial pillar of a rule-based global order. The relevance of its mandate in today's world is as clear and pronounced as it was in 1998, when the international community galvanized and adopted the Rome Statute, committing to fight impunity for the world's gravest crimes. We vouch that never again should not ring hollow to the suffering victims, and that the rule of law should not succumb to the whims of power and politics, but rather that perpetrators must answer to the power of the law, and that indeed power must no longer be a shield and a ticket to impunity. Today in 2020, that struggle continues. Against this challenging backdrop, my office is working tirelessly in the independent and impartial conduct of its core activities of preliminary examinations, investigations, and prosecutions, and to hone its performance in these respects, with a view to contributing to establishing a culture of accountability. We have seen helpful progress, including the recent unanimous sentencing of Mr. Bosco Ntaganda and decisions confirming the charges and committing to trial cases against Mr. Al-Hassan, as well as Mrs. Yakatom and Gai Sona. My office has initiated additional investigations in relation to the situation in Bangladesh, Myanmar, and concluded its preliminary examination into the situation in Palestine, with the determination that all the statutory criteria under the Rome Statute for the opening of an investigation have been met. The specific jurisdictional ruling on the question of scope of territorial jurisdiction I have sought in this matter by requesting judicial review of the correctness of my position before I embarked upon an investigation has generated much interest from key stakeholders, as well as considerable media frenzy. For my office, this step is part and parcel of our independent legal mandate and what it means to be a responsible prosecution office. We also await an appeals judgment with respect to the situation in Afghanistan. All the aforementioned developments will contribute to a charged judicial calendar of 2020. Your Excellencies, ladies and gentlemen, esteemed colleagues, as we work to effectively and efficiently implement our judicial and prosecutorial duties, the court will be subject in the coming weeks and months of a review by independent experts who are asked by the Assembly of States Parties to look at our functioning. My office and the court as a whole welcome this timely and important review as an exercise to further strengthen the performance of the court and the Rome Statute system as a whole. We look forward to the substantive interactions with the experts and to elaborate in detail on the improvement measures that have already been taken or identified in furtherance of the court's and the office's strategic planning, including in areas relating to completion strategies, prioritization, resource management, and in-court performance. That said, it is important that we do not lose track of the court's operating environment, notably in the face of the ever-increasing assaults to undermine our credibility and tarnish our independent and impartial work and the international rule of law more generally. No review of the court's functioning will be effective or complete if we do not at the same time proactively discuss and anticipate further attempts to derail the wheels of justice, and indeed how states parties as custodians of the Rome Statute must stand firmly by its side. Courage and conviction must always guide our actions to protect our common values and goals, and even more so in this challenging year ahead of us. We owe it to the victims of the unimaginable atrocities that continue to plague our continent and who continue to look at the court as a beacon of hope and justice. We owe it to the betterment of humanity and to future generations so that they may live in a more secure, peaceful, and just world as the founders of the Rome Statute so rightly envisaged. I, along with my dedicated and tireless team in this courtroom and across my office, look forward to working with you in the discharge of our independent and ever necessary mandate. I thank you for your attention.
Thank you, Madam Prosecutor. Now I invite Mr. Peter Haynes, QC, President of International Criminal Court Bar Association, to address us.
Madam Secretary General, Mr. President, Madam Prosecutor, Your Honours, Your Excellencies, ladies and gentlemen. The International Criminal Court Bar Association, or ICCBA, was founded 3.5 years ago, and I am its 4th president. It's an unfortunate statistic, but I'm the 4th man who has held the office and the 3rd lawyer from the United Kingdom. Those statistics rather belie the diversity and gender balance of our membership, and it would be fitting in the not-too-distant future were you to receive an address from a female, somebody whose first language wasn't English, a person of colour, or perhaps somebody who ticked all 3 of those boxes. But for the time being, it's my profound privilege to address you on behalf of the association. The membership of the association numbers about 340, and it represents those who are on the lists of counsel at the ICC and those who act in junior roles as support staff. The association is not, like its counterparts at the ad hoc tribunals, an association of defence counsel alone, but rather one which welcomes those who defend the accused and also represent victims. Its membership, moreover, embraces those who are employed directly by the court itself within the offices of OPCV and OPCD. The importance of a bar association to a developed judicial system is well-trodden ground, but if you'll forgive me, I'll highlight some of the areas why it is so important and underline what the ICCBA will regard as its core objectives. It will help to ensure that the bar remains independent from political interference through self-regulation. It will ensure that everybody who practices before the court plays by the rules. Not just that people don't cheat, but that they're insured, pay their subscriptions, and observe currently accepted standards of behaviour. It will ensure that those who represent those who appear before the ICC, whether defendants or victims, are up to the job. They have appropriate qualifications, appropriate training, and appropriate continuing professional development. It will enable practitioners to exchange ideas and experiences, both within the membership of the Association of the Bar, but also with opponents, the judiciary, and the court's administrators. There is, at the end of the day, no substitute for experience. And it will ensure that those who fall outside the central structure of the court have a voice in legislative changes, legal aid funding, and basic lawyers' rights. On the other side of that coin, a bar presents as a focal point for the court to seek the views of independent professionals who use it, and presents as a genuine interface for collective bargaining. Lastly, but not leastly, a bar offers a pastoral element to its membership, even a social one. For all the merits of a training course, the drinks reception at the end of it is often just as important to people who are a long way from their homes and families. Now, this is not the first time that the President of the Association has had the privilege of addressing this particular occasion, but the opportunity this year has an especial poignance. For last year, at its 18th session, the Assembly of States Parties passed a resolution effectively recognising the ICCBA as the Bar Association of the Court. Now, of course, having had the opportunity of addressing the ASP, I would have you believe that this unprecedented turn of events was a direct consequence of my powers of advocacy. But in truth, it was time. For over the past 3.5 years, the association has increasingly been recognised within the court as a body which ought properly to be engaged in all operational issues. Indeed, it is currently playing a full role in cooperation with the registry, the facilitator, the Committee of Budget and Finance, the Chambers, and the Office of the Prosecutor in matters including the amendment to the court's legal aid policy, protocols and practice directions concerning procedures relating to pleas of guilty, initiatives to improve the processes by which evidence is presented to the chambers of the court, and mechanisms to ensure that those who work here are protected from harassment or abuse. Now, that work would inevitably have been ongoing anyway, but recognition by the Assembly of States Parties was a significant step forward, not just for the association, but for the court too. There will be closer and more direct collaboration between those who practice at the bar and all organs of the ICC, which will benefit all aspects of judicial and administrative operation. In the coming year, the association looks forward to playing a full and active part in the court's review process. Its considerable resources will be at the disposal of the court pro bono to help ensure that the process delivers a court both fit for purpose and fit for its time. The ICCBA will continue to reach out and forge association with bars around the world, spreading the court's message. Affiliation agreements have been signed with the Belgian and Kuwaiti bars. A similar agreement with the French bar is in train. Training programs are planned in Ukraine and Jakarta. And as President, I've been invited to represent the association at the Pan-African Lawyers Union, the African Bar Conference, the Union Internationale des Avocats. The training committee will again provide programs in-house for its membership, as well as those who work in international criminal law in the various institutions here in The Hague. The association's working group on gender parity, equality and welfare has and will continue to work hard together with the staff union at the ICC to establish protocols and procedures for victims of harassment to have appropriate avenues to raise their concerns. And the association is working with the registry to refloat the trust fund for family visits by independently seeking individual voluntary contributions from states, so that those who may spend a decade awaiting knowledge of their fate do not do so in isolation from their families. In all these ways, the ICCBA demonstrates and will continue to demonstrate that it is entirely supportive of the strategic aims of the ICC and that it stands ready to prove itself a valid and valuable partner in delivering them. Thank you very much.
Thank you very much, Mr. Haynes. Now, I pass the audience over to the Registrar of the Court, Mr. Peter Lewis. Mr. Lewis.
Baroness Scotland, Mr. President, Your Honours, Madam Prosecutor, Mr. President of the Bar, Your Excellencies and distinguished guests, ladies and gentlemen, and colleagues from the Court. It's a great honour to address you on the opening of the 2020 Judicial Year. As I speak to you today, the people of the Registry, here in the Court, and in our country offices, are supporting the Trust Fund for Victims in delivering reparations to victims, protecting witnesses and victims, and engaging with affected communities, providing a safe and secure environment for those in detention, providing legal aid for defendants and victims, and through the independent offices of the Registry, providing support for the defence and providing representation for victims. We work with states to provide cooperation, including in the vital area of the execution of warrants. We ensure we recruit the best people for the court and look after the resources the states parties have given us. And in this courtroom, today, the Registry, through our interpreters, through our reporters, in due course through our translators, through the court management staff, are ensuring we can communicate with each other and, in due course, that what we do here today is available for the world to see. And besides these, we do very many other important tasks. Because of the vital work we undertake, we who work in the Registry are acutely aware that what we do matters, whether it's as individuals or in our teams. That is why we will be guided in all we do this year by our three priorities: to continuously improve, to increase staff engagement so we get the most from the people who work in the Registry, and to make a real difference to the geographical representation and gender balance of the court. I'm very proud to lead the people of the Registry who work tirelessly, diligently, respectfully, and with a strong commitment to the mission of this court. That mission is only possible because of the support of the states parties who provide us with our finances, provide the staff, the people of the Registry, and who work to provide us with the cooperation that's the lifeblood of this institution. In 2020, we are determined, as in previous years, to demonstrate the value of the investment that the citizens of the states parties have made in this court and in the vital course of international criminal justice. Thank you.
Thank you very much, Mr. Registrar. Now we will hear a second musical intermezzo. Thank you so much for that wonderful piece. I now have the immense pleasure of introducing our guest of honor and keynote speaker, Baroness Patricia Scotland, Queen's Counsel, the Secretary General of the Commonwealth. Her presence here today attests to the good relations between the court and the Commonwealth, particularly the support that she and her organization have for the court. But in addition to her current function, Baroness Scotland is also a very highly accomplished barrister in her own right. Amongst other things, she was the first black woman to be appointed Queen's Counsel and the first woman to be appointed as Attorney General of England and Wales. During her government career, she played a critical role in the ratification and implementation of the Rome Statute by the United Kingdom. We're truly honored and privileged to have her with us. Madam Secretary, you have the floor.
Mr. President, Madam Prosecutor, Mr. Registrar, honourable judges, colleagues, learned friends, and esteemed ladies and gentlemen. It is a pleasure and an honour to be here at the International Criminal Court for the opening of the Judicial Year. And I hope that it will be a salve to the President of the International Criminal Court Bar Association that I, as the only woman ever to be appointed as Her Majesty's Attorney General for England, Wales and Northern Ireland since the institution of that office in 1315, and the first and only woman to be Commonwealth Secretary General, am privileged to address you today albeit, I regret, in English. The International Criminal Court is a remarkable organisation, and as a barrister of more than 40 years standing and the former Attorney General of the United Kingdom, I have, in the course of my career, attended quite a number of openings of the Judicial Year. This one, however, is unlike any other, as it takes place in an institution many thought would never come into being. The International Criminal Court is the realization of a dream, shared by many, that victims of the most serious crimes could be granted justice at the international level. The court was designed to end impunity for the perpetrators of these heinous crimes, no matter how high the level they were. No one would be above its reach, including heads of state. Here we are now, in 2020, with the ICC established in its permanent premises, with 27 ongoing cases, 12 situations under investigation, and 9 preliminary examinations. The court is, of course, not immune from criticism, and it is an organisation in constant evolution, striving to fulfil its mission of ending impunity as effectively as possible. However, challenges and negative criticisms should not deter us, nor obscure the fundamental fact that a working international criminal court is in itself a victory for the rule of law. The moment actually is quite a poignant moment for me, as this court's development and history and mine have been curiously intertwined over the last 20 years. As a foreign minister in the House of Lords, I was responsible for introducing the legislation which would pave the way for the ratification of the Rome Statute by the United Kingdom. It was the first bill for which I was solely responsible, and its importance was unmistakable. National jurisdictions were to remain the first line of defence against impunities of mass atrocities. The ICC was to be a safety net, the court of last resort. It was this view that guided my work in the House of Lords, and my colleagues in the House and I found ourselves occupied with the finer points in international criminal law, such as the question of state and diplomatic immunity, the question of jurisdiction, and the law on sentencing by the ICC. We, however, remained alive to what the Rome Statute meant for us, for the United Kingdom, the Commonwealth, and for the world at large. We hoped to retain the integrity of the statute as it signified the creation of what was potentially the most important institution for the prevention of crimes and the protection of human rights created by the world community in 50 years. The UK's aim was to become founders of the court, and we were successful among the first 60 states to ratify the statute. On the 13th of July 2011, the then President of the ICC and the then Commonwealth Secretary General signed a Memorandum of Understanding to strengthen and develop cooperation between these two organisations to jointly support states implementing international criminal law. Now, almost 10 years after our two organisations entered into this historic Memorandum of Understanding, I, as Secretary-General of the Commonwealth, an intergovernmental organisation representing more than 1/3 of the world, find it serendipitous that I am called upon to continue the work I so dutifully began in the United Kingdom Parliament 20 years ago, albeit in a different capacity. The Commonwealth brings together 53 member countries which share common democratic values and a rich legal heritage for the purpose of encouraging international cooperation. Of the 53 member countries of the Commonwealth, 36 are parties to the Rome Statute, and that number looks as if it is likely to rise, which is over 60% of our membership. The Commonwealth prides itself on the diversity of its membership. Among our Commonwealth member countries are some of the most populous in the world and some of the least populated, with little more than 10,000 inhabitants. We include within our membership advanced economies and developing countries and an incredible diversity of traditions. This diversity is also reflected in our member countries' relationship with the International Criminal Court. There are Commonwealth countries which feature amongst the long-standing supporters of the ICC, while others of our members have expressed doubts about the court. The Commonwealth's large membership is connected by its past and its future, by language and by institutions. It is also united by its common values, which are set out in the Charter of the Commonwealth adopted in 2012. Whilst there may not be a unanimity as to how the ICC is perceived by Commonwealth member countries, the values shared by both organisations present important similarities. Through the Charter of the Commonwealth, all member countries have stated that international peace and security, sustainable economic growth and development, and the rule of law are essential to the progress and prosperity of all. The ICC not only plays an important role in promoting international peace and security, but was in fact designed in part to do so. In fulfilling its mandate to promote accountability for the most serious crimes and endeavouring to deter future crimes, the ICC contributes to restoring order in post-conflict areas and creating and preserving peace. The ICC was established to punish aggressors who might decide to perpetrate these heinous crimes where the rule of law systems in states fails. Its true purpose, however, is to make true that which our forebears proclaimed at Nuremberg in 1946, that never again will the world community be indifferent in the face of mass atrocity and impunity, ignore the plight of the vulnerable, or be silent in the face of evil. This is not only an ex post facto mandate to punish the wrongdoers. It is a commitment we have made to prevent a repeat of what has previously brought our world to its knees. The Commonwealth community honours this commitment by developing its own national elements in parallel with these international ones. Today, the Commonwealth that came together in 1949 to sign the London Declaration is committed to the pursuit of peace. Peace versus justice has been an ongoing debate, but in my view, a false debate. Whether justice is delivered through the International Criminal Court, domestic courts, or other mechanisms, lasting peace is virtually impossible to attain without justice. Our Charter expresses it clearly. International peace and the rule of law are essential to the progress and prosperity of all. The protection and promotion of the rule of law is the cornerstone of our organisations. To refer again to the Charter of the Commonwealth, member countries have committed to the promotion of the rule of law as an essential protection for the people of the Commonwealth. Commonwealth countries are connected by a shared commitment to the rule of law as the answer to the ever-changing problems of the world. To achieve peace entails the institutionalisation of the rule of law principles in Commonwealth members. These principles, which are respect for human rights, access to justice, combating impunity, and the deep respect for humanism, anchor our pledge to one another as Commonwealth member states and to the world community and its institutions, such as the International Criminal Court and its enabling statute, the Rome Statute. A justice system that is fair is an indispensable precondition for democracy. To be effective, it has to be trusted, which means it has to be accessible to all and composed of strong institutions which are legitimate and beyond reproach. That is why building strong public institutions capable of delivering sustainable democratic development has always been central to the work of the Commonwealth. Access to justice does not just mean access to court. The ultimate end of the court system is to deliver justice. Therefore, we are undertaking a deep examination of the human and technical errors that prevent or jeopardize the delivery of quick and efficient justice to our member states. At the end of their meeting in Colombo last November, Commonwealth law ministers adopted the Declaration of Equal Access to Justice. In this declaration, they endeavoured to ensure the adoption of a broad understanding of access to justice that looks beyond access to dispute resolution mechanisms only and focuses on equality of outcomes. They also committed to removing barriers faced in accessing justice. The theme of the meeting led to a fascinating discussions among law ministers on how they address the justice needs of their populations, including the justice needs of those who are specifically vulnerable and the groups which were found within their jurisdictions. Law ministers shared examples of traditional justice mechanisms, special tribunals, and successful collaborations between justice, health, and social services. And among the interesting outcomes of these discussions was the conclusion that justice is not always found within the walls of a courthouse. Justice may have a very different meaning depending on the individuals involved. At the international level, the challenges in bringing access to justice, as found at the domestic level, are somewhat expanded due to the worldwide repercussions. The International Criminal Court is familiar with the near impossibility of ensuring that all victims of the most serious international crimes have access to justice. The sheer number of people affected, directly or indirectly, by these crimes tends to make access to justice for all an insurmountable challenge. The ICC cannot provide the answer to every need for justice and redress. In crimes of the scale with which it deals, there are broader needs of memory, for record history, and for education. This is where the principle of complementarity becomes important. With this in mind, Commonwealth nations seek to realise their commitment to increasing access to justice, and we realise that we need to keep in mind the victims of offences such as war crimes, crimes against humanity, and genocide. The ICC was not designed to hear from all victims of these crimes, so it is critical for domestic justice systems to be equipped to provide some form of redress. The inclusion of international crimes in domestic law represents an important step in this process, to be followed then by effective prosecution. At the Commonwealth Secretariat, our role is to assist our member countries to fully meeting their international obligations. The Commonwealth Secretariat has developed the model law to implement the Rome Statute of the International Criminal Court and to provide assistance to countries in their efforts to include international crimes in their domestic law, whether or not they are parties to the Rome Statute. We must remember that access to justice is also heavily dependent on the extent to which populations have trust in institutions. Due to the intense and worldwide scrutiny which the ICC faces as an international institution, its credibility is essential to its success. That credibility comes in large part from the fairness of the proceedings and the independence of its actors, particularly the prosecution and the judiciary. According to eminent jurists, there are links between crimes committed during conflict and organised crime. International crimes do not occur in a vacuum, but are deeply intertwined with organised crime and corruption. For example, there appeared to be a symbiotic relationship between war crimes and organised crime before, during, and after the conflict in the former Yugoslavia. Curbing corruption then becomes not only an economic, but also a human security imperative. The Commonwealth is consequently developing the anti-corruption benchmarks, which will be presented to Commonwealth heads of government for endorsement at their next meeting in Rwanda in June this year. The benchmarks address the importance of combating corruption in the court system and enabling the judiciary to operate effectively and independently. At the international level, independence of the judiciary takes on a whole new meaning. A credible international court requires an international and representative judiciary, which is not an easy task to achieve, as it also means working with different legal backgrounds and traditions. The responsibility of this court and the responsibility this court faces is immense, and the eyes of the world are upon it, watching the way proceedings are conducted, the judgments made, and the decisions issued, developing international jurisprudence which will then be used across the world as a reference when prosecuting international crimes, represents a truly unique opportunity. All judges contribute to the evolution of the law, but the judges of this court, this illustrious court, have the privilege of exercising this function in a unique and highly visible way. Because as each of the esteemed judges here today who form part of this court will be discussing during today's seminar, predictability and consistency are significant considerations in the context of the ICC. The court has clarified the law concerning sexual violence during war, the use of child soldiers, ethnic persecution, other innumerable crimes visited upon civilians, and has developed mechanisms to afford tangible reparation to victims. It has indicted warlords and the heads of state, incumbent and former, who are required to answer charges of gross human rights violations while demystifying the law on immunities. This is highly commendable work, and the international community should take real pride in it. Our Commonwealth campaign towards equal rights for women has resonance with other campaigns against injustice and discrimination, including those against child, early and forced marriage, people trafficking, modern slavery, female genital mutilation, and other forms of sexual and domestic violence. Gender-based violence in armed conflict tends to be more prevalent in societies where inequality between men and women is deeply entrenched. The Commonwealth can play a role in upholding the commitments made in its charter on gender equality and women's empowerment as essential components of human development and basic human rights. The nature of the cases before the court, this court, is evolving. The court is now looking at matters which are heavily political and potentially polarizing. These cases are also evidence that the world is gradually retreating from the violent impulse that defined most of the last century. The ICC, in keeping world leaders accountable and aware of the consequences of their action, even under immense scrutiny and criticism, is achieving a tremendous feat. The court offers an alternative to the violent solution. It gives reason for restraint. At this juncture, the world needs the International Criminal Court to stand the test of time and to realize the high expectations for a more just world, which were the motivation that led to its creation. World leaders must abide by the principles of accountability that gave birth to this court, the principles of prosecutorial and judicial independence and autonomous systems of adjudication. This will truly democratize our world. The Rome Statute triggered a difficult and urgent process. It exposed the uncomfortable relationship of politics and justice. It also triggered a deeper self-examination of our approach to reparation and the complex interplay between politics, justice, and peace. It was poignant to listen to the Honourable President today in his erudite speech, which echoed much that he said on the 13th of January of this year in the op-ed in the Globe and Mail. But I believe he was right to urge calm, confirming that the sky was not caving in for the ICC. It is, after all, a court of law, though operating in an extremely politicized environment. And I agree with him that though the ICC encapsulates the imperfections of international law, it deserves our support because it remains a mechanism of great value to humanity, not least because it has truly served to loosen tyranny's grip on humanity in our own time. In devising capacity-building measures such as developing training and assistance programs for national judges, prosecutors, and other criminal justice officials in the fields of international humanitarian law and criminal law, the Commonwealth offers its unreserved support. The reason is because this institution and its underlying treaty represents the best of humanity. It is a monument to what we can do together, in parallel, nationally and internationally. So in conclusion, I believe it is appropriate to wish this court all strength, courage, wisdom, and an open mind as this judicial year begins. I would like to thank you for the privilege offered to me today to address you as you undertake your duties, not only in a new year, but a new decade. As judges, your role in achieving these expectations is central and decisive. I can think of no greater encouragement, no more inspiring incentive than that on which to be setting out on a new year. The world needs this court. It needs its sagacity, its energy, its commitment, and its judgment. And on behalf of the Commonwealth, I wholeheartedly give you my thanks and my support for the work that you have already undertaken, but I thank you far more for the work you will do. Thank you very much indeed.
Thank you very much, Madam Secretary General, for those most inspiring words. Very powerful reminder of what this court is all about and how we got here. Thank you. Before we conclude the proceedings, we will invite the Lazarus String Quartet to perform for us the final time. Thank you so very much. Excellencies, ladies and gentlemen, that brings us to the close of our session for this morning. I thank you very much for being with us. I now formally declare as commenced the Court's Judicial Year 2020. The proceeding is adjourned.
All rise. We will lever.